All right, welcome to the deep dive. Today, we're taking a very specific stack of information and diving in deep. Our source material is actually an excerpt from an instructional update. It's,
Yeah.
designed for individuals working within the Texas justice system.
Right. Think of it like a foundational training document.
Exactly.
Yeah.
TCOLE course,
Yeah.
hashtag 3188, covering the 88th state and federal law update for 2023-2025. So
Yeah.
pretty specific stuff.
That's absolutely right. And this isn't just some general reading material. This particular training, it's mandatory
Mandatory.
for Texas peace officers, jailers, telecommunicators, judges, and even prosecutors. It's really designed to get them, up to speed on significant legislative changes and recent court decisions that directly impact how they do their jobs every single day.
Okay, so that's the official audience.
Yeah.
But our mission here is to unpack this, technical information for you, the listener.
Right.
Whether you're maybe involved in law enforcement, studying it, or maybe you just have a keen interest in understanding the rules that govern your community and the people who enforce them. We're going to try and extract the most important sort of nuggets of knowledge from this.
Yeah, pulling out the key stuff.
We're looking specifically at the impact of the 88th Texas legislature that was the session back in 2023 and how its decisions are shaping the legal and, the operational landscape from 2023 right through 2025.
And, staying updated on these changes, it's not just about checking a box for compliance. It's really fundamental to effective, constitutional, and importantly, safe law enforcement.
Right.
Things change. Laws evolve, court interpretations shift all the time, and anyone in these roles, they absolutely must understand the current legal framework just to operate correctly and fairly.
And for the public, why should they care?
Well, for the public, understanding these changes gives you insight into the evolving standards and the expectations that are placed upon law enforcement. It helps you understand the system better.
Makes sense. Now, the source text itself, it gives us some context. It highlights some recurring themes from that 88th legislature session.
What did it point out?
It explicitly mentions a strong law and order focus. So, legislation aimed at cracking down on crime.
Right.
Also, a significant response to the ongoing fentanyl crisis, which is huge right now.
Absolutely.
And a continued emphasis on enhancing school safety across Texas.
Huh.
So as we explore the specific legal changes in this training, you should keep these broader themes kind of in the back of your mind.
Yeah, they provide the political and social backdrop, really, the context that drove a lot of these legislative actions.
Exactly.
Now, the source document itself, it's structured. It's broken down into distinct modules.
Now so.
It covers TCOLE administration, that's the Texas Commission on Law Enforcement. Then it gets into the penal code, the code of criminal procedure, the transportation code, school safety stuff, and federal updates as well. It's pretty comprehensive for the professionals using it.
Okay. And we're basically going to follow that structure, right? Diving into the sections that were provided to us in this excerpt.
That's the plan.
We'll start where the source starts with
Mhm.
those administrative changes, the ones impacting TCOE itself and how agencies are required to operate.
Right at the foundation. But, it's really crucial to state up front, and the source material itself says this too,
What's that?
that this deep dive, much like the original training module we're looking at, it's a summary. It's an educational tool.
Okay. Important disclaimer.
It is not a substitute for, reading the full text of the actual laws that were passed, or for getting legal counsel about specific situations. We're analyzing the information as it's summarized in this professional training document. We're looking at that material.
Got it. We're looking at the summary provided to professionals. And there's a key detail mentioned right at the beginning about effective dates.
Ah, yes. Dates are critical in law.
Very. So unless it specifically notes otherwise, like a different date, most of the laws we'll talk about became effective on September 1st, 2023.
Okay.
We'll be sure to point out any specific dates that are mentioned in the source because, in the legal world, timing is absolutely everything, isn't it?
It really is. Those effective dates, they dictate when the rules actually change on the ground. So, yeah, they are vital pieces of information from this source.
Okay, let's roll up our sleeves then. Let's unpack this first section, Module 1. This is all about TCOLE and law enforcement administration updates.
Right. And based on the source text, the objectives for this module are pretty clear.
What are they aiming for here?
It's about understanding key changes to TCOLE rules and policies, new requirements that are placed upon law enforcement agencies themselves, and also new mandated training requirements.
So foundational stuff.
Exactly. These are the shifts that impact the sort of organizational framework, the operational procedures for law enforcement agencies across Texas. It's really about the infrastructure and the oversight of the profession itself.
Okay, so we're starting with the rules about the people who enforce the rules.
Mm-hmm.
Makes sense.
Mm-hmm.
These aren't changes to, like, specific criminal offenses yet, but rather the administrative landscape that governs the people and the agencies handling those offenses.
Correct. The framework first.
So let's jump into part one. Key changes to TCOLE rules and policies. The source says this section details the specific administrative and regulatory shifts from the 88th legislature.
Yeah, and these changes, they directly influence TCOLE's regulatory authority and how agencies are required to uphold professional standards and accountability. It's really about reinforcing the integrity of the whole system, kind of from the top down.
Okay, here's where it gets really interesting because the source kicks this section off with a pretty significant piece of legislation, House Bill 872. What did this bill do regarding minimum standards for agencies?
Okay, HB 872. This established a very clear directive for TCOLE. The bill tasks TCOLE gives them the job of establishing and maintaining minimum standards for law enforcement agencies all across the state.
So it wasn't just advice before, now it's a mandate.
It's an explicit mandate now, yes, to set a baseline for how agencies operate.
Okay, TCOLE sets the standards. What about the agencies themselves? What does this new rule require of them?
Well, the source is pretty unequivocal on this point. It states that agencies must adopt and comply with these minimum standards set by TCOLE.
Must, so not optional.
Not optional at all. This compliance is a requirement, and it's tied directly to an agency's ability to, well, maintain its status as a licensed law enforcement agency in Texas.
Wow. So failure to comply could actually put an agency's license at risk.
That's the implication, yes. It adds a significant layer of authority to TCOLE standards.
And does the source give us the why behind this? What's the intended purpose of HB 872?
The source states that this bill reinforces a baseline of operational integrity statewide.
Operational integrity. What does that really mean in this context?
That's a good question. While the source excerpt doesn't, list every single specific standard TCOLE might set, in the context of law enforcement, that phrase implies foundational requirements. Things like officer training levels, maybe agency policy development standards, possibly minimum equipment requirements, and just overall professional conduct.
So setting a floor.
Exactly. It's about ensuring that no matter where you are in Texas, there's a certain minimum level of professionalism and capability that law enforcement operations shouldn't fall below.
Okay, so for you, the listener, why should you care that Texas law enforcement agencies now have these mandated minimum standards from TCOLE that they must comply with?
Well, because these standards directly impact the quality, the professionalism, and frankly, the reliability of the law enforcement agency serving your community.
How so?
A mandated baseline means there should be less variability in performance and accountability from one town or county to the next. Higher minimum standards, if they're enforced statewide, are intended to translate into, better trained officers, clearer and more consistent policies, and ultimately a more effective and trustworthy agency interacting with you, the public.
So it's really a foundational piece aimed at enhancing the quality of law enforcement services across the board.
That's the goal, yes.
Yeah.
Setting the bar higher and making sure everyone meets it.
Got it. Okay, moving on. The source highlights some really significant changes to a specific but very important administrative form, the F5 separation of licensee form.
Ah, the F5. Yes, that's a critical one.
Tell us about this form first. What is it generally used for?
So the F5 form is completed by a law enforcement agency whenever one of their licensed officers leaves employment. It doesn't matter the reason: resignation, termination, retirement, anything else. It's a formal record of that officer's separation from that specific agency. And this information, it's typically shared with TCOLE and becomes part of the officer's record. Future agencies where the officer might apply can access this. It's essentially part of their official employment history within the Texas system.
Right, and the change under the 88th legislature, the source mentions the old way involved subjective designations.
That's right. The source points out that previously, the F5 form included these specific subjective labels. They were chosen by the agency head who was filling out the form.
Like what?
Terms like honorable, general, or dishonorable discharge. They were used to categorize the nature of the officer's separation.
Okay, those sound pretty loaded. So they moved from those subjective labels to what's the new way under House Bill 30 as amended by House Bill 4419?
The key change here is that these specific subjective discharge designations, honorable, general, dishonorable, they've been eliminated from the F5 form.
Gone completely.
Gone completely. They are no longer used or included when an agency reports an officer's separation.
And this change, it has a very specific effective date mentioned in the source, right?
Yes, and that date is critical to remember. This change applies to F5 forms submitted for separations occurring after March 1st, 2024.
After March 1st, 2024, so recent.
Very recent. So any officer who separated from an agency on or before that date, March 1st, 2024, well, their F5 might still have included one of those subjective terms. But for any separation happening after that date, the new form without those categories is the one being used.
Okay, if the subjective labels are gone, what does the form still require? What does the agency have to put down about the separation?
The source is clear on this. The form still requires detailed factual information about the circumstances surrounding the separation.
Factual information. So instead of just picking a label.
Right. Instead of selecting a single, potentially loaded term like dishonorable, the agency must provide a narrative or specific details. They need to explain the reasons the officer left or was separated.
Okay, let's really unpack the why here. This feels like a pretty fundamental shift in how things are documented. The source says this change aims to provide more objective information for future employing agencies. What are the full implications of that, moving from labels to facts?
Oh, it's a really significant change, both philosophically and practically. Those subjective labels, they're inherently open to interpretation, aren't they? And potential bias.
How so?
Well, think about it. An honorable discharge might gloss over some minor disciplinary issues that didn't rise to a level the agency had felt warranted, say, a general discharge, but a future employer might still find those details relevant.
Yep.
Conversely, a dishonorable designation could be slapped on based on maybe a disputed incident or even just a personality conflict between the officer and the chief. It could unfairly hinder an officer's future employment chances, even if the underlying facts are complex or maybe less severe than that label implies.
So it lacked nuance.
Precisely. By removing these labels, the intent, as the source summary puts it, is to basically force the hiring agency to look at the specific facts provided by the previous agency.
They can't just rely on the summary word.
Exactly. They have to actually read the detailed account. For instance, if an officer was terminated, the new form should describe the specific policy violations or the conduct issues that led to that termination, rather than just saying dishonorable.
So does this make it harder or easier for agencies when they're evaluating candidates who have previous law enforcement experience?
That's a great question. It almost certainly makes it require more work for the hiring agency and potentially more expertise in evaluating those facts.
More work out.
They can't just quickly filter applicants based on a glance at the discharge type, right? They have to thoroughly review the factual narratives for every previous separation listed. Now, this could be a deterrent for agencies that maybe only do minimal background checks. However, for agencies that are really committed to thorough vetting, it actually provides potentially richer, less biased information to base their hiring decision on. It shifts the burden of interpreting the significance of the separation more firmly onto the shoulders of the hiring agency.
Okay, and thinking about accountability versus fairness to the officer themselves, how does this change try to balance those two things?
It's definitely a delicate balance this change is aiming for. For the officers, removing a potentially stigmatizing label like dishonorable might feel fair. It prevents their entire career from being potentially defined by a single subjective assessment from one point in time. It allows the facts, ideally, to speak for themselves.
And for accountability, does removing the label weaken it?
Well, the intent is actually the opposite. The idea is that requiring detailed facts actually enhances accountability. Problematic behavior, misconduct, performance issues, they have to be specifically documented rather than just vaguely categorized under a broad label. Future agencies are meant to be able to see precisely why an officer left a previous job. So the accountability comes from the documented facts being available, not just the label assigned by the prior employer.
Okay, so for you, the listener, this change directly impacts the kind of pipeline of information that's used when a law enforcement agency in your community is considering hiring an officer who previously worked somewhere else in Texas.
That's exactly right.
It changes the nature of the historical record they receive and, importantly, how they must evaluate it now.
It's a fundamental change in how officer employment history, especially around separations, is officially documented and shared within the state. And that's a critical step in the hiring and vetting process, which is ultimately designed to ensure officer quality.
All right, really interesting stuff there on the F5 form. Let's transition now to another major piece of legislation covered in this section.
Hmm.
The source introduces this as a significant step for pre-employment screening, Senate Bill 1445. So what does this bill primarily address?
Okay, SB 1445. This one introduced multiple changes, all really aimed at bolstering accountability and transparency within Texas law enforcement. The first major component that's highlighted in this training material is a new mandatory requirement during the hiring process.
Another mandate.
Yes, this one involves searching a national database.
A national database. Okay, which specific database is mandated by SB 1445 according to the source?
The source names it explicitly. Before hiring a peace officer, agencies in Texas are now required to conduct a search of a national law enforcement decertification database.
Decertification,
For
meaning
officers who have lost their license to practice law enforcement. The specific database mentioned is the one maintained by the International Association of Directors of Law Enforcement Standards and Training, that's IADLEST.
IADL-EST.
Okay. Or, more specifically, its National Decertification Index, which is often called the NDI.
IADL-ST's NDI. So agencies have to check this specific national index now. What's the core purpose behind requiring this check? Why do this?
The stated purpose, according to the source, is to ensure that individuals who have had their law enforcement licenses revoked or suspended in other states are identified during the Texas hiring process.
Ah, okay. So this directly addresses that long-standing concern, sometimes called the wandering officer or bad apple problem, right? Where officers might lose their license in one state.
Exactly, and then just move to another state, like Texas, and get hired again without that serious history being readily apparent.
So this aims to prevent that.
Precisely. It aims to close that loophole. It establishes a national layer of screening specifically for the most serious disciplinary actions, those that result in license revocation or suspension. It means Texas agencies now have a mandated tool, a requirement, to check if an applicant has a history of being formally barred from law enforcement somewhere else in the country.
This sounds like a key mechanism, then, intended to prevent officers with documented histories of serious disciplinary problems or actual license revocations elsewhere from easily getting a job in Texas.
It absolutely is. By requiring this check, the legislature, as summarized here, is clearly aiming to enhance overall officer quality and build greater public trust. The idea is to prevent individuals with truly problematic histories from re-entering the profession undetected just by crossing state lines. It's a significant step towards more national accountability in law enforcement licensing.
Okay, that's one major part of SB 1445. But it also includes another major initiative focused on transparency, doesn't it? The source highlights the establishment of a public-facing, searchable database.
Yes, this is a very important transparency measure also mandated by SB 1445. TCOE, the state commission, is specifically tasked with developing and maintaining this new public database.
And what exact information about a Texas peace officer will this public database make available? What can people see?
The source specifies that this database will allow the public, anyone, to search for and view the current license status of any Texas peace officer.
Current license status?
This includes whether an officer's license is currently listed by TCOE as active, inactive, suspended, revoked, or if the individual is deceased. So the basic standing of their license.
Okay, let's delve into the implications of searchable and public-facing. Who exactly can access this? And what does this increased level of transparency really mean for accountability and public trust?
Well, public-facing means exactly what it sounds like. This database is accessible to anyone with an internet connection. That means you, me, members of the community, journalists, researchers, defense attorneys, even other law enforcement agencies wanting to verify something quickly. Absolutely anyone can potentially look up an officer's license status.
And searchable.
Searchable means you can likely look someone up, probably by name or maybe their TCOLE license number if you have it. You don't need special access.
So this is a pretty direct and, frankly, powerful pathway for public oversight, isn't it?
It really is. It means that the official status of an officer's fundamental qualification to serve their state-issued license is no longer information primarily held just within law enforcement agencies or TCOLE's internal systems. The public can now independently verify this crucial piece of information directly from the source, TCOLE.
Wow. That feels like a really significant step towards increasing public trust, maybe, and accountability. You, as a member of the community, will actually be able to verify the license status of an officer who serves where you live.
It is undeniably a major shift in transparency. It empowers citizens, empowers the public, with information that just wasn't so readily available before.
Mm.
And this increased visibility, it's intended to foster accountability, right?
Mm.
By making it easier for the public to know if an officer is currently licensed and considered in good standing by the state's regulatory body.
And that builds trust, potentially.
That's the hope. It builds trust by demonstrating a willingness from the state level to make key credentialing information public.
Okay, SB 1445 sounds like a weighty bill.
Mm-hmm.
And it doesn't stop there, does it? The source covers one more critical aspect under this bill: mandatory reporting of failed fit-for-duty examinations.
Yes, this part of the bill addresses officer fitness and capability. The requirement here is that if a law enforcement agency requires an officer to undergo a specific type of examination, a psychological or physical fitness for duty examination.
What's the purpose of those exams, generally?
They're assessments to determine if an officer is still capable, mentally and physically, of safely and effectively performing the duties required of a peace officer.
Okay. And if the officer fails that exam?
If the officer fails that required examination, the head of that agency, the chief, the sheriff, whoever is in charge, must report this failure directly to TCOLE.
Okay, they have to report it. Is there a specific timeline for that reporting mentioned?
Yes, the source specifies a clear timeline. The agency head must report the failed examination to TCOLE within 30 days of the officer failing the assessment.
Within 30 days. That ensures TCOA gets notified pretty promptly.
Yeah.
And what authority does TCO gain under SB 1445 related to these failed exams? What can they do with that information?
This bill grants TCOLE new explicit authority. They now have the power to suspend an officer's license if that officer fails a mandatory fitness for duty examination, and this is key, has not been restored to fitness for duty within a specified time frame.
Ah, so it's not automatic suspension on failure, but if they fail and aren't deemed fit again within a certain period.
Correct. While the source summary just uses the phrase specified time frame without giving the exact duration, it clearly indicates TCOLE now has the power to act on these failures if the officer doesn't regain fitness for duty.
What's the underlying rationale here? Why implement this rule, according to the source?
The source states this provision underscores the vital importance of making sure that all officers remain capable both physically and psychologically of safely and effectively performing their, frankly, very demanding duties. It ties directly into public safety and the operational necessities of law enforcement work.
Let's think about that for a second. What kind of issues are these fitness for duty exams likely designed to address, and why are they so critical for this specific job?
Well, the source doesn't detail the exact content of the exams, but based on standard practices and just the nature of the job, these exams assess critical capabilities. Physical fitness exams might test things like an officer's stamina, strength, agility, their ability to handle the physical demands, like maybe restraining someone who's resisting, engaging in a foot chase, or safely using their equipment under stress.
Right. Physical demands are obvious.
And the psychological evaluations, those are crucial for assessing an officer's mental and emotional stability. Their ability to make sound judgments under extreme pressure, handle repeated exposure to trauma, interact appropriately and safely with diverse people, especially in volatile situations. Judgment, decision-making, emotional regulation.
All critical?
Absolutely critical. If an officer is deemed unfit in either of these areas, physical or psychological, it poses a clear risk to themselves, to the fellow officers, and certainly to the public they serve. So this rule ensures TCOLE is made aware of such findings and has the authority to intervene by potentially suspending the license if that fitness issue isn't resolved.
So this mandate, it's directly tied to ensuring the officers who are out there interacting with the public, making split-second, potentially life-or-death decisions, are actually physically and mentally capable of handling the unique and often dangerous demands of the job, safely and competently.
That's precisely it. It's fundamentally about ensuring officer readiness and ultimately public safety. It's another layer of accountability and oversight designed to make sure that the individuals entrusted with the authority of a peace officer meet the necessary standards of physical and mental capability throughout their careers.
Okay, that covers the major points from SB 1445 in this section. Finally, the source briefly mentions updates related to TCOLE advisory committees. What's that about?
Yes, the source just notes that there have been some updates regarding these committees and how they function. Their primary role, as described, is to ensure there's continued input from professionals working in the field, currently serving law enforcement officers, administrators, trainers, people like that.
Input on that.
Input on matters related to training standards and licensure standards. keeping things relevant.
So these are more like internal TCOLE structural things, but they're still important because they influence how future rules and training requirements might get shaped.
Correct. While it's not a direct regulatory change affecting agencies or the public in the same way as the other items, these committees are vital. They help keep TCOLE's standards and requirements grounded in the practical realities and the evolving needs faced by people on the front lines of law enforcement.
A feedback loop.
Exactly. It's a mechanism for incorporating field expertise into the administrative decision-making process at TCOLE. The source provides very little detail beyond mentioning them, so we won't, dive into specific committee structures, but their continued function is noted as relevant to the overall administrative landscape.
Okay, I think we have thoroughly unpacked Module 1 now. The TCOA and Administrative Updates section, based directly on the source material we have, this professional training document excerpt. Let's quickly summarize the essential key takeaways from this initial administrative deep dive, just hitting the main points as presented in the source.
Okay, sounds good. Let's recap the most important points from this module. First, House Bill 872. This establishes new minimum standards for law enforcement agencies statewide. TCO is now explicitly tasked with setting and maintaining these standards.
And agencies must comply.
Yes, agencies must adopt and comply with them to keep their operational status. The goal stated is reinforcing a baseline of operational integrity across Texas.
Okay. Second big takeaway. The significant changes to the F5 separation form, thanks to HB 30 and HB 4419.
Right. The key there is the removal of those subjective discharge types, honorable, general, dishonorable, for any separation occurring after March 1st, 2024.
Focusing on objective facts instead.
Exactly. The shift aims to give future hiring agencies more objective, detailed factual information about why an officer left a previous job, requiring them to evaluate the circumstances rather than just relying on a potentially biased label.
Got it. Third key point, and a major component from Senate Bill 1445, those new mandatory national decertification checks during hiring.
Absolutely critical. Agencies are now required to search that IDA List NDI database before hiring a peace officer. The purpose is to identify individuals who've previously had their law enforcement licenses revoked or suspended in other states.
Closing that loophole.
Trying to, yes. Addressing the issue of officers moving between states to avoid past disciplinary records.
Fourth takeaway, also under SB 1445, the creation of that new public-facing searchable database for TCOLE license status.
That's a big one for transparency, as we discussed. This database allows anyone, the public included, to search for and verify the current license status of a Texas peace officer. Active, inactive, suspended, revoked, or deceased. It's a direct tool for public oversight and building trust.
Okay. And finally, the last key takeaway from this administrative module, the one covering officer fitness.
Correct. Also stemming from SB 1445, it's the requirement for agencies to report failed mandatory fit-for-duty exams, physical or psychological, to TCOLE within 30 days.
And TCOLE's new power.
And TCOLE's new explicit authority to potentially suspend an officer's license if they fail such an exam and their fitness isn't restored within a specified time frame. This is crucial for ensuring officers maintain the necessary physical and psychological capabilities to do their job safely and effectively.
Okay. So these points really represent the fundamental administrative and regulatory changes impacting the structure, the oversight, and the personnel standards of Texas law enforcement agencies, all stemming from the 88th legislature, at least based on this part of the source material.
And while, these might initially seem like just bureaucratic updates, maybe dry administrative stuff.
Yeah, not the exciting crime-fighting changes yet.
Right. But as we've discussed, they have direct and really tangible impacts on accountability, on hiring practices, on overall officer quality, and importantly, on transparency, all of which are critical components of a well-functioning, trustworthy law enforcement system.
That's a good point. Now, the full source material, this TCLA training document, it indicates that it covers many more areas beyond just administration.
Oh, yes.
Including significant updates to the penal code, the code of criminal procedure, the transportation code, specific school safety measures, and federal law changes, too. There's clearly a lot more in the full scope of the 88th legislature's impact.
Definitely.
However, for this specific deep dive, based on the excerpt we were working with, we have focused entirely on the introductory context and this crucial first module, detailing the changes affecting TCOA and the administrative requirements.
And that makes sense. These initial administrative changes, they really establish the regulatory environment. They set the standards for the individuals and the agencies who are out there enforcing the law. It kind of sets the stage before you even get into the specifics of the many criminal laws themselves that were likely amended or created in that session.
All right, well, we've taken this specific piece of Texas training material and used it as our guide to explore its introduction and that first module on TCOL and administrative changes. We've tried to pull out what the source material itself identifies as the key need-to-know points for professionals and hopefully explain them in a way that makes sense and highlights their significance for you, the listener, even if you're not in law enforcement.
We can clearly see how these administrative changes, though maybe less visible sometimes than changes to, say, criminal penalties, they do tie back directly into those broader themes the source mentioned right at the beginning.
How so? Remind us of those themes.
The strong law and order focus, the response to the fentanyl crisis, and enhancing school safety.
Okay, so how do these admin changes connect?
Well, think about it. Strengthening minimum standards for agencies with HB 872, enhancing the vetting of officers through national checks with SB 1445, improving the documentation of separations with the F5 changes, and ensuring officer fitness, again with SB 1445. All of that directly supports the goal of a stronger law and order framework by aiming for more professional, more capable, and more accountable officers on the street.
Makes sense. Better officers, better enforcement.
And the increased transparency, particularly through that public license database mandated by SB 1445, that supports public trust. And public trust is absolutely essential for effective law enforcement, whether they're tackling complex issues like the fentanyl crisis or working to ensure safety in schools. You need community buy-in and trust.
That's a really good connection. But so even if you aren't a Texas law enforcement professional, understanding these foundational rules, these administrative shifts, it gives you really valuable insight, doesn't it?
I think so.
Insight into how the system is structured, the mechanisms being put in place or attempted anyway to improve accountability and transparency, and the fundamental standards that are expected of the officers serving your community. It's a critical lens, really, through which to view the entire justice system.
And what's fascinating here, I think, is how these seemingly administrative, maybe even bureaucratic changes, like the details on a separation form, HB 30, or the establishment of a database like SB 1445 mandated.
Things that seem minor on the surface.
Exactly. They seem minor, maybe, but they're actually foundational tools. They have potentially profound implications for ensuring officer quality and for building or rebuilding public trust. If we connect this to the bigger picture, it really raises an important question, I think, for you, the listener, to maybe ponder.
Okay, leave us with a thought.
Given this increased transparency that's being mandated, particularly with things like the public database for officer license status, the question becomes, how can communities effectively use this new information? How can you use this access to engage constructively with your local law enforcement agencies? And maybe work towards stronger relationships that are built on, mutual understanding and genuine accountability.
That's a powerful thought.
Yeah.
How does transparency translate into action and better relationships? Something to definitely think about. Well, thank you for joining us for this deep dive into this specific segment of the Texas Law Enforcement Update material.
It was definitely a complex, but I think highly relevant set of administrative changes to explore, a lot packed into those bills.
It really was. And unpacking sources like this, taking technical information and trying to make it accessible, it really is, we hope, a shortcut to being better informed about the systems and the standards that impact all of our daily lives. We look forward to the next source we get to dive into with you.